Chers collègues, mesdames et messieurs.
Colleagues, ladies and gentlemen, we're 3 minutes behind schedule. Not too bad, not too bad. And I've taken some structural decisions as it happens. We're not going to have a break between now and the last panel because actually we don't have that much time. Our interpreters will be taking their flights, and maybe later on, by the way, we'll perhaps say a few words about how we felt about their performance, particularly for those of you who use their services. But we will have to release them on time, is the point I'm making. So we will now work without interruption until the end of the day. The first roundtable for this afternoon is all about space. We're going to project ourselves into outer space. This morning we talked about extraterritoriality. Here we really are in the extraterritorial. I'm sure you'll agree. So there is a link, there's a connection, although it is a tenuous connection because I think the approach will be somewhat different. This panel, once again, is one that relates to a research and study centre project. We have, of course, a publication. The exact title, I'm afraid, escapes me right now, but it's a publication, a book that is all about outer space, and it is absolutely indispensable, I think. And I'm sure we'll hear more about it in a moment. We have the two directors with us. I mean, I don't think there are that many people who have written about this particular subject. And, of course, we have eminent speakers, so we'll listen very, very carefully indeed. And I hand it over to you. Thank you.
Vos Excellences,
Excellencies, dear colleagues.
Read correctly, il y a un question mark behind that. Merci beaucoup pour avoir établi cet centre de recherche.
Thank you very much for establishing this research center back in 2017 at the Academy. Thank you, Secretary General, dear Jean-Marc. And many thanks to Peter.
The results of our Center of Research by two presentations of the directors. First of my esteemed colleague, Professor Philippe Achilleas from the University of Paris-Saclay, who will talk about developments of space exploration and use, in particular in view of new users, private users, then followed by my presentation on the evergreen topic on whether or not one can appropriate the moon and its resources. And I tell you, I come with new secrets. And then followed by our splendid student, Tuğrul Çakır, who will talk about outer space and the celestial bodies vis-à-vis the developing countries, the attitude of developing countries. We have planned for some discussion and, of course, for questions from the floor, and would be delighted. But I now first give the floor to Philippe Achilleas.
Monsieur le Secrétaire.
Secretary General, Excellencies, dear colleagues and dear friends. I too would like to take this opportunity to thank the Academy's Curatorium at the Hague Academy of International Law. Thank you for choosing space as a topic that we addressed in 2017 at the Academy's Centre for Study and Research. We carried out this work with my dear colleague, Professor Hobe, and young researchers, and it allowed us to highlight a lesser-known area of international law. You can't imagine how many times I was asked, does space law actually exist? Or indeed, you can't imagine the number of times people made mocking remarks saying, well, space law, that's the law of aliens. However, all of this, of course, was without taking Elon Musk into account. Indeed, in this great space adventure, I would say that there's a before Elon Musk and an after Elon Musk. Elon Musk and other wealthy entrepreneurs from Silicon Valley have been developing ambitious space projects, and they have revived our interest in the conquest of space. And even though they are doing this, we are, of course, very aware of the fact that they are far removed from the ideals that inspired the pioneers on this great journey. Within the space of just a few years, space has changed dimension. Until 2010, I would say, activities were focused really on the launching of a few satellites every year, no more than around 60, no more. But then, in 2022, last year, nearly 2,500 satellites were placed into orbit. And Elon Musk's Starlink constellation alone comprises 42,000 satellites. It's true that all societies today depend on space. I don't know whether you're aware of the fact that each and every one of us uses 47 satellites every day, from getting up in the morning to when we go to bed at night, 47. So we're using space, we're using this service in a countless number of fields without even necessarily being aware of it. And therefore, I think we can safely say that space and space applications affect many areas of national sovereignty. With that as a backdrop, the Centre for Study and Research of the Hague Academy decided that it would ask about the principles that are laid down in the Space Treaty, a treaty that was signed back in 1967, and to see to what extent it's compatible or apposite for the new space ecosystem. I mean, I personally have to say, I think the Space Treaty is one of the finest texts of international law. If you haven't read it yet, please do so. I warmly recommend it. It is a treaty that reflects a vision of the world where science is at the service of humankind as a whole. And, even better, its purpose is to preserve space from the kinds of mistakes that we have made on Earth, protecting it from any form of appropriation and limiting its use to peaceful activities. So today, ladies and gentlemen, I turn to you, and I have to be honest with you. I'm a little saddened, I'm a little concerned that some of these fundamental principles are currently being called into question. Let's take, for instance, the principle of non-appropriation of space and celestial bodies, as enshrined in Article 2 of the Space Treaty. Well, in 2015, the United States of America passed a law that authorized private companies to exploit the resources of celestial bodies. The Americans then led the way. Other states followed in their wake. Other states also passed similar legislation, entering a market that was still very hypothetical, of course. And then in 2022, the United Nations finally, at long last, set up a working party to address this issue. But the question is no longer whether the exploitation of resources of celestial bodies is lawful under international space law, but rather how we can best regulate this activity. There's also the ITU, International Telecommunications Union, which is the other major organization that is in charge of space issues. It, too, has been confronted with this wave of commercial exploitation of space. The ITU has adopted a whole raft of procedures to enable states to use frequencies and orbits without risk of interference. So in other words, the ITU, as an organization, plays an essential role in giving effect to the freedom of space, which is laid down in Article 1 of the Space Treaty. However, no one at this stage can predict what will happen next. Will the system be able to function, notwithstanding the proliferation of satellites, particularly, of course, with the launch of constellations? It's already too late to curb the pollution of space, which has become a kind of gigantic dustbin with the explosion in the amount of debris that we see. Added to which you have light pollution. Thousands of satellites launched into low Earth orbit can now be seen with the naked eye in the middle of the night. And above all, this has an effect on the activity of astronomers because they generate trails of data collected. Let's move on to the principle of peaceful use. That's the other major rule that characterizes the status of outer space, according to the treaty. The signing of the Space Treaty at the time was presented as a major event to promote peace. War in space has been avoided, the press reported at the time. And it's true that in 1958, and that was just 1 year after the launch of the Earth's first artificial satellite, Sputnik, the UN General Assembly, in its very first resolution devoted to space, the UN General Assembly recognized the principle of its use for exclusively peaceful purposes. So, in other words, the resolution prohibits military use or applications in space. 1 year later, another resolution, which again reiterates that any use has to be peaceful, but it does delete the verb, exclusively. And by deleting exclusively from the sentence, it paves the way for the militarization of the cosmos. Just 1 year later. What happened? Well, the space powers, realizing the importance of satellites for military surveillance operations, no longer wished to reserve space for just civilian activities. Then, in 1983, President Reagan presented on television, live on television, an anti-missile shield. The press dubbed it Star Wars, with reference, of course, to George Lucas's famous film. The weaponization of space, in other words, the fact that we're placing weapons in orbit around the Earth, this has become a reality now for everyone. Admittedly, the project didn't see the light of day, but the race to weaponize space was well and truly on. Initially, it was quite discreet, but since 2007, it's been very much out in the open. China conducted a first anti-satellite missile test in that year. The space community at the time was shocked by this act. It had catastrophic consequences for the space environment. Now, it destroyed one of its satellites. That in itself is not banned by the treaty, but nevertheless China, by so doing, created a huge cloud of debris. The United States, India, Russia have followed suit. They too have carried out tests, and the latest tests have actually been carried out in a climate of indifference. And since then, there have been hostile or unfriendly maneuvers in orbit, more and more. Patrol satellites, deliberate jamming, interception of communications, blinding of satellite sensors, etc., etc. And several states are demonstrating their military capabilities in space now. In 2019, believing that a war in space is now inevitable, the US and France have set up armed forces dedicated to space. The war in Ukraine, of course, seems to be proving them right. For the first time, a cyber attack has been carried out against a European space service. Now, despite these setbacks, there are still reasons to be optimistic. First of all, Article 6 of the Space Treaty, which introduces a rule that is actually unique in international law. It specifies that states are always internationally and directly responsible for their national activities in space. This is very important to note, including those carried out by private entities. They are still responsible. So in other words, it obliges governments to put into place a system of authorization and ongoing monitoring of private space operations. So we're talking about national laws, domestic laws, thanks to which international legislation on space is imposed upon these entities. So contrary to what some might tell you, space is not some kind of legal Wild West. No, the state still remains at the heart of the game, and no private company can escape state control, not even SpaceX. Secondly, civil society, which is increasingly critical of the abusive exploitation of space. I mean, let's be honest, the image of billionaires spending astronomical sums of money to have fun in space is quite frankly in stark contrast to that of traditional astronauts. Traditional astronauts, according to the Space Treaty, are considered as envoys of humankind, envoys into space. Associations have actually lodged a complaint against the operating licenses for the satellites in the Starlink constellation. And in 2022, the French Conseil d'État ruled in their favor, cancelling the authorization given by the telecommunications regulator for lack of public consultation. Now, Starlink, since then, has obtained authorization in accordance with procedures in force in France. And in the US, in the face of protests, and it gets even more complicated, Starlink has just reached an agreement with astronomers. Finally, space has always been a fertile ground for cooperation. I take the example of Apollo-Soyuz, the mission of 1975 during the Cold War. And today, of course, we have the International Space Station. The extreme tensions that we're seeing right now, caused by the war in Ukraine, have still not interrupted cooperation between the USA and Russia on the International Space Station. Cooperation today must be expanded to the private sphere. Companies, many of which act in the interests of and on behalf of their governments, have now become major players in the development of international space law. Indeed, international space law is increasingly based on industry practices, inspired by industry practices. And another important point I would make, the industry would very much like to take part in the crafting of international space law. They're asking for their seat at the table. Cooperation and international law therefore remain essential to the harmonious and responsible development of space activities. I think that is clear to all. It's obvious to the entire space community, and indeed the space powers continue to affirm their full support for the principles set out in the Space Treaty. There are many challenges to be met if space is not to become an area of tension, or worse still, if uncontrolled proliferation of debris is not to make man a prisoner of his own planet because it is impossible to access space. I'm thinking here in particular of the management of space traffic. However, despite all of the above, I'm convinced that when the Academy puts space law back on its agenda, we will be in a position to appreciate the great progress made in preserving the idealistic spirit of the 1967 Space Treaty. Thank you very much for your kind attention.
As announced,
Comme dit, je vous parlerai.
For centuries, if not millennia, humanity has gazed at the stars and the moon and wondered what it must be like far beyond the reaches of our home planet. From Galileo, Copernicus, Jules Verne et Cyrano de Bergerac to Hermann Oberth and Hermann Nordung, books about the cosmos, humanity's travel there, and other questions about the final frontier have been written across all spheres of human knowledge. But it wasn't until 1969 that humanity finally accomplished one of the greatest achievements to date, the landing on the moon. On July 20th, 1969, several billion people across the globe watched on their television sets the transmission of the historic event, as Neil Armstrong, astronaut of the famous Apollo 11 mission, took his, quote, small step for man, giant leap for mankind, and became the first man to step on the surface of another celestial body, our Earth moon. This is one of the most well-known facts in current history. Less known is the international legal order that governs the final frontier and man's activities. And there were all early writings, such as a famous person, Vladimir Mandl, that as early as 1932 wrote a short manual, a short book in German, I must confess, he was German Czech at that time, so on the moon, on man's travel to the moon and other stars. Despite numerous writings of eminent experts, inter alia the former president of the International Court of Justice, Manfred Lachs, it wasn't until 1967, only 2 years before the extraordinary moon landing, that the first international treaty on space law was adopted within the United Nations and entered into force, the Outer Space Treaty. This has a much longer name in practice, but we abbreviate it here. Conceived as a compromise between those two great space powers of the era, the United States of America and the Soviet Union, it is characterized by a close connection to the use of outer space for military purposes, technology, political aims in the overall atmosphere of the Cold War, the then ongoing arms race and nuclear tests. It was unclear which country would reach the final frontier first, but both superpowers were aware that the one that controlled outer space would likely control the Earth, and that is true today as well. Today, the Outer Space Treaty has 113 state parties and is largely considered customary international law. It is the foundational document for all human activities in outer space, often referred to as the constitution of outer space, including the moon and other celestial bodies. 12 years after its adoption, the United Nations adopted and opened for signature the fifth and final space law treaty, the Moon Agreement, valid also for the other celestial bodies of the solar system, a specified document creating binding rules for the exploration and use of the moon and other celestial bodies in the solar system. In large parts, the Moon Agreement reiterated the principles of the Outer Space Treaty, expanding on some in order to detail the exploration and use of the moon, in particular regarding the issue of moon resources. This, however, turned out to be controversial in the views of many states and resulted in only 17 ratifying countries so far. Both the Outer Space Treaty and the Moon Agreement are supplemented by a wide corpus of general international law made applicable to outer space activities through Article 3 of the Outer Space Treaty and Article 2 of the Moon Agreement. We have in Article 1 of the Outer Space Treaty the general freedom of exploration and use as for the benefit of mankind. In Article 2, a non-appropriation clause, the prohibition of the appropriation of the moon, not specifically of the resources. In Article 4, a demilitarization clause that is a partial demilitarization as outer space is concerned and a total demilitarization as the celestial bodies are concerned. And in Article 9, which is a bit explainable because it was before environmental law really took off with the Stockholm Conference, and this is, of course, 1979, so a little bit earlier, a provision that seemingly aims at environmental protection, but is, in my personal opinion and the opinion of many, not really very good for that. But this would be necessary, very necessary, has been already mentioned by my colleague Philippe Achilleas, because the interesting orbits today, where we have a lot of satellites of the various sources, are constipated and are full of space junk. We call this space debris, and it is very difficult to get rid of that. It is particularly costly, and therefore, if we think of the polluter pays principle, all spacefaring nations are pretty reluctant to touch on that subject. Now, in totality, the principles explained designate the moon and the area beyond national jurisdiction as a res communis omnium. And while the appropriation of it is forbidden, the wording of the Outer Space Treaty's articles is too broad to amount to a prohibition of economic or commercial activities. In as long as these are not undertaken for the sole advantage of one state, the commercialization of the moon is not interdicted. This brings us to the heart of this presentation today: the legal status of lunar resources and their commercialization. The legal status and the question of an appropriation of resources is less clear than that of the lunar surface. The Outer Space Treaty does not expressly mention resources. Opinions on whether the term appropriation by means of use, that was a quote, or by any other means, as in Article 2 of the Outer Space Treaty, encompasses resources remain divided. The unclear wording of the Outer Space Treaty illustrates the fundamental nature of the Outer Space Treaty that, at least in this case, will require concretization for operational use. This is what the Moon Agreement attempted to do. In its Article 11, the Moon Agreement addresses the question of resources, stating in paragraph 1 that, and now comes a key word, the moon and its natural resources are the common heritage of mankind. Article 11 goes on to distinguish between the moon and its natural resources, creating two legal systems. Under paragraph 2, it decrees that the moon is not subject to national appropriation, with paragraph 3 clarifying that neither the surface nor the subsurface of the moon nor any part thereof or natural resources in place shall become the property of any state, intergovernmental, international or non-governmental organizations, national organization or non-governmental entity, or of any natural person. For natural person resources not in place, the agreement specifies in paragraph 5 of Article 11 that state parties to this agreement, I quote this, hereby undertake to establish an international regime, including appropriate procedures to govern the exploitation of the natural resources of the moon as such exploitation is about to become feasible. Under this agreement, then the mining of lunar resources would be legal under the conditions that an international legal regime for the exploitation, as specified in paragraphs 5 to 7 of Article 11 of the Moon Agreement, would be established by the international community. Therefore, in light of the Outer Space Treaty's silence or vagueness on the matter, and the Moon Agreement's low ratification status, only 17, a new multilateral agreement is, in my opinion, required, which must address the following questions. First, do we, as the international community, as mankind, wish to permit space mining? Would a 20 to 30 years moratorium akin to the Antarctic arrangement perhaps be the best solution? And secondly, if we wish to permit space mining now, under which conditions should it be permitted? It cannot be without conditions. The Lotus Principle, saying that all that is not expressly prohibited is permitted, is not applicable directly for the international common spaces, since this lex specialis in international law starts from the opposite premise, namely that action in the international common spaces is in principle prohibited and must be specifically allowed. In line with the Outer Space Treaty and evolving international law, conditions must, at the very least, require environmental protection of the lunar environment and an international agreement. The international agreement must detail how space mining and the exploitation of resources will be carried out. The mining agreement could take the form of either a first come, first served approach, which is the traditional and which gave rise, by the way, to all the international agreements that wanted to get rid of this old-fashioned approach. Secondly, a licensing system under the deep seabed legal regime. This has perhaps seen most experience so far, and guidance can be gained from the International Seabed Authority in the United Nations Conventions on the Law of the Sea, or possibly even jurisprudence of international tribunals. Or thirdly, a principle of equitable sharing. This could also be a possible solution for a model. In the words of the International Court of Justice in the Continental Shelf case from 1982, equity as a legal concept is in direct emanation of the idea of justice. Would, for example, equitable sharing mean that the establishment of an international fund that all states pay in? And if so, is this at all a viable option in today's geopolitical atmosphere? Or could the jurisprudence of the International Court of Justice help us to determine equitable sharing? Perhaps. The court is, in the words of the court in the Continental Shelf case from 1982, bound to apply equitable principles as part of international law and to balance up the various considerations which it regards as relevant in order to produce an equitable result. Perhaps the idea has already been outlined in Article 11, paragraph 7 of the Moon Agreement and should be upheld. Article 11, paragraph 7 reads, The main purposes of the future international legal regime to be established shall include: first, the orderly and safe development of the natural resources of the Moon. Second, the rational management of those resources. 3, the expansion of opportunities in the use of those resources. And 4, and an equitable sharing by all state parties in the benefits derived from those resources, whereby the interests and needs of the developing countries, as well as the efforts of those countries which have contributed either directly or indirectly to the exploration of the Moon, shall be given special consideration. The latter formula highlights the intention of the drafters of the Moon Agreement to guarantee a portion of the benefit from space travel also to the so-called developing world of the Global South, which has not invested in such activities. In my opinion, the spirit should, in whatever form, be maintained in the future legal regime. Therefore, it is time to come up with a second generation of space law. Being confronted with the concrete possibility of the exploitation of resources of celestial bodies through private enterprises and their possible settlement on celestial bodies takes into account the different goals of: first, preserving freedom of action and investment; second, a fair distribution of the benefits; and third, a sufficient degree of environmental protection. Therefore, my final thoughts are: humanity is returning to the Moon, and international law must precede it. I thank you very much for your time.
Vos Excellences,
Excellencies, dear colleagues, I would like to thank the Curatorium of the Academy for its invitation. Thank you very much. My presentation is entitled The Concept of Space Development Between Idealism and Realism. In the process of adopting the Space Treaty, the United States and the Soviet Union wanted to achieve peaceful competition between themselves. As far as their relations with non-space states were concerned, the two powers' main intention was to obtain a guarantee of the freedom to use space. However, this freedom set out in the first article of the Space Treaty is not absolute. The limitations placed on it constitute a safety net to prevent the monopolization of space. We can therefore stress that there is a fair balance not only between space powers, but also between space powers and non-space states. In addition to this balance, there is another between developed and developing countries, which has also influenced the development of space law. It is the recognition of the res communis status of space that best reflects this practice. In this presentation, we will ask whether this balance is still maintained by studying the concept of res communis from the point of view of developing countries. We can argue that space law has an idealistic and humanist dimension. Firstly, we will emphasize that it is this idealism in particular that makes the use of space beneficial to all countries. Secondly, we will point out that this idealistic spirit has its limits, and that the individualistic behavior of certain states can jeopardize the maintenance of the initial balance. First, we will focus on the first article of the Space Treaty and then on its implementation. According to the first article of the Space Treaty, the exploration and the use of space shall be for the benefit and in the interest of all countries, irrespective of their stage of economic or scientific development, and are the prerogative of all of mankind. The principles set out in this article are interdependent. The concept of the prerogative of mankind means that the exploration and use of space is in the interest not of certain countries, but of all countries. The concept of mankind's prerogative must therefore be understood in the light of the principle of using space for the good of all countries. In other words, freedom of space is allocated to serve the common interest. The principle of using space for the benefit of all countries can only be achieved through cooperation, which is recognized as the best way of sharing benefits. However, states are not obliged to share their space benefits. If the space powers resort to cooperation, it is also because it is in line with their interests. As Professor Hobe pointed out, sharing the benefits of space can also contribute to stability in international relations and is in the interest of all countries. Having briefly recalled the first article of the treaty, we can now examine its implementation. Today, developing countries use space technologies on a daily basis. They have access to space either through their own resources or through international cooperation. The emergence of new space has facilitated access to space, particularly for developing countries. Indeed, access to space has become simpler thanks to the miniaturization of spacecraft and lower launch costs. This is contributing to the democratization of space. However, there is often a lack of resources or obstacles to the application of space technologies in developing countries, which requires international cooperation. A number of initiatives have been put in place to fill this gap. For example, the UN Space Applications Programme aims to facilitate the use of space technologies in developing countries. Similarly, one of the objectives of the International Committee on Global Navigation Systems is to promote the use of navigation systems in developing countries. Finally, the service offered by satellite navigation system providers to anyone in the world and the accessibility of all the data collected by American satellites in the field of earth sciences are just two examples to underline that the development of space technology in one country can be considered as progress for mankind as a whole. The landscape above shows that developing countries have the opportunity to access space technologies. However, we are witnessing a weakening of certain principles that is jeopardizing the original balance. Before proposing solutions to restore balance, we will highlight the weakening of fundamental principles. We will focus on three principles: the principle of non-appropriation, the principle of peaceful use, and the principle of environmental protection. In the current context, we are witnessing a proliferation of national legislation relating to the exploitation of space resources. These manifestations of unilateralism are worrying insofar as they risk harming the interests of developing countries that do not have the means to exploit space resources. This unilateralization may have the consequence of intensifying the race for resources and consequently threatening international peace and security. The military use of space is legal as long as it is not aggressive. In the current context, it is rather the weaponization of space that is worrying. The anti-satellite tests carried out by the space powers and the establishment of space commands confirm this trend. This could lead to war in space, which would have major consequences for the long-term viability of space activities. One of the major issues in space law is the protection of the space environment, particularly with regard to the issue of space waste. This has also become a fundamental concern for developing countries. We are now going to suggest possible solutions in order to redress the balance. We believe that the Moon Agreement takes account of the common interest and has struck a balance between the developing countries and the space powers. Given the space powers' mistrust of the concept of the common heritage of mankind, it would be useful to clarify it by amending or revisiting the agreement. Once amended, it would be possible for certain space powers to change their position on the agreement. Given the strong opposition of the USA to the Sino-Russian project, it would be more logical, indeed, to focus on the security of space activities rather than the disarmament of space. In this context, the adoption of a binding instrument on the security of space activities discussed within the Committee on the Peaceful Uses of Outer Space would be a more appropriate solution. Such an instrument could build confidence and ease tensions between the space powers while taking account of the interests of developing countries. We believe that the establishment of space traffic management would be necessary in order to ensure the long-term viability of space activities. Indeed, the long-term sustainability of space activities is a matter of common responsibility for all states. The transposition of the principle of the differentiation of responsibilities in the space field concerning the prevention of space waste and the cleaning of orbits would be in line with the telos of the Space Treaty. By way of conclusion, the concept of res communis has played a major role in the philosophy of the conquest of space, and in order to provide more concrete answers to the issues raised, a philosophical perspective needs to be developed. Space law offers states freedom, but expects them to behave responsibly. This is all the more crucial in the context of the commercialization of space activities and the weaponization of space. Thank you.
So thank you very much to my fellow panelists. And we have another 15 minutes for discussion. I would like to just say two sentences because, of course, the very subject title puts a question mark. Can outer space be res communis? And I would say the typical answer of the lawyer is it depends. Well, which is never wrong and never entirely right. So it depends very much on whether, for example, the international community will have the strength to develop a system to clean outer space and the orbits, which very much depends on their sense for, well, we have the same problems on Earth, that we have the same, well, climate problems here. Secondly, that perhaps the developing, well, an international system, usage system for the resources of the celestial bodies, well, it may very much depend on the concrete size. A little bit we have it, and Philippe Achilleas had said that because the International Telecommunication Union established a distribution system and a distribution regime that pays tribute to those who cannot actually, for example, use a specific position. So everything is pretty open, and that gives again, well, we are so grateful to the far-sighted fathers in this way for this research center that we enjoyed a lot. And of course, now the floor is open for you. If you don't want to co-comment, sorry.
Non, ça va.
Okay.
Je crois qu'il y a une question ici.
Okay, please, sir.
Oui, on va prendre.
Two more questions.
Thank you very much. I'm Roberto Righetti from the European Patent Office. Thank you very much for the presentation, which was very interesting, all the presentations. I would like to refer to your first it depends question, because I think it's very important to clean up the orbits. Otherwise, we are speaking about nothing, because nothing could be done afterwards if the orbits are not cleaned up. And my question is, what are the legal instruments that exist now to do something, and what can do the international community, and especially the legal international community, to help solving this issue? Thank you.
Thank you very much indeed. I think we have two more questions and then we start a round of answers.
Merci. Stéphane Furcht, ancien auditeur vieilli de Berlin.
Thank you very much. From Berlin. I wanted to ask you, might it be feasible to restrict the use of extra atmospheric space for military purpose even more than at present, and if so, how?
On the University of Sevilla, Spain. I'd like to ask, because it's not my domain, but in which way the Tibet authority regime can be an inspiration for a future regime, as there is also a non-declaration of sovereignty of the Tibet area, but there is a regime that allows appropriation or exploitation, specifically mining, of the resources. Thank you very much.
Thank you very much. Now we start with the table ronde des réponses. Tu prends.
Je vais commencer sur les...
Thank you. I'll start perhaps with the cleaning up of waste space in orbit. This issue has been on the agenda of the United Nations. There's an interagency group which has been set up to adopt technical guidelines based on industry best practices. I did say this earlier. Space law, international space law, today is premised upon industry practice. It was in 2002 that these guidelines were adopted. They were also supported by the UN General Assembly. However, they are not binding in any way. So from an international law point of view, we only have technical texts. However, if you look at domestic, in other words, national space law, that is designed to regulate space activities, in particular private space activities, I should tell you that France was the first country to introduce a technical obligation, its purpose being to restrict or to curb space waste. Operators are under an obligation to get rid of the debris by whatever means, 25 years after the end of the mission. There are many technical points. I shan't go into them now. But again, it has to do with placing the debris at an orbit that is sufficiently low so that just naturally the debris will disintegrate by friction with other materials. The United States has also introduced regulations 5 years after the end of the mission, which is very interesting to note. Why are the Americans doing this? Well, first of all, they can. The US industry is ready. When France adopted its rule on 25 years, we weren't there yet. But the US are ready, and they want to set a high standard, abide by that standard, and then say that everybody else is falling short of that standard. Also, there's a so-called cemetery orbit, which has been established at 36,000 kilometers altitude. So just before the end of life of the satellite, you briefly ignite the engine in order to place the satellite a few hundred kilometers above so that it is in the right area in this so-called cemetery space.
A few sentences. I'm very much fond of economic incentives. I think that international law in general has to change towards not so much has to be prohibited, but there should be more incentives to do the right thing. And I see, for example, if we are in the era of new starting private enterprises, one could say, that is my proposal, I'm still lonely on that, for each mission you must pay in a fund. And this money that is in the fund is used for cleaning outer space. And in fact, there is already an industry, the technique is there. you can, well, there is a vacuum cleaner, so to speak, for outer space, or you can pull and push, and then these debris pieces melt away. So if we have also for that an economic incentive to do that, I think that could be more promising than hoping that countries will do at the end of the day the best. That presupposes that we get away from the polluter pays principle for the past. Because of course, the main contributors were, well, including the European countries, let's say. As to military, this is a very sad chapter. One thing must be clear from the very beginning. Outer space is therefore of extraordinary interest and importance because it can be used for military purposes. And there is the biggest loophole in the Outer Space Treaty, was the most important for the major space powers. It's in Article 4, paragraph 1, that says, and I translated already in what is allowed, you can allow intercontinental ballistic missiles that use only half an orbit to come from Vladivostok to, let's say, Los Angeles. That was the insurance, so to speak, the insurance policy for the big superpowers that they could do. And guess why the People's Republic of China likes this regime as well. So they are very, very much of all of them of controlling these things. And what I only see is trying to use a system that starts much lower. First of all, there is, as far as my knowledge is concerned, no militarization yet of the celestial bodies, which could be a next point of escalation, that you deposit something on Mars or somewhere, you know, huge things, and that you can work. The Guerre de l'Étoile was, of course, something that aimed at protecting, giving 100% protection to one country, which is against any military strategy, because then you cannot be wounded anymore, and this is the end of anything, of any policy of, you know, making that. So I am not extremely optimistic as military users of outer space are concerned, but I think the only policy we can attribute is to control who possesses nuclear weapons. And we do have this NPT treaty, for example, and that more or less functions, because the greatest danger, I think, in our times is that terrorist groups get hold of these weapons. I cannot say more, but Philippe.
Je crois qu'il est très très important de comprendre que depuis le début,
I think it's very important to understand that from the outset, space technology has been military technology. In fact, it all originates from Germany, end of the Second World War. All of these space technologies are military by definition. You can't make a difference or a distinction between a missile and a launch pad. You know, in fact, the same device can be used for spying purposes. In a year, the UN changed its position. The space powers believed that it would be absolutely unthinkable to have a purely civilian space. In fact, today, no army would like to proceed with a foreign military operation without resorting to space. So the infrastructure is a military infrastructure in space. That is the logic that we're in now, and it will continue. We're seeing it with the war in Ukraine. We're developing space services for military purposes. But in addition to that, you need to protect these military installations. I mean, army or military vulnerability is in space now, after all. So we're thinking about lasers and so on and so forth. It is a kind of a circle, if you like. We're circling the circle. And unfortunately, I can't really see states curbing or cutting down on the weaponization of space.
J'aimerais bien rebondir sur la question de la militarisation.
I would like to also speak about the issue of weaponization or militarization. So originally the idea was to completely demilitarize space, but that did not happen. In Part 4, mention is made of partial demilitarization of orbits, total demilitarization of celestial bodies. But as Professor Achilleas just said a moment ago, space is now a militarized domain. So I think it unfortunately needs to be recognized as such. However, we should address this issue from the point of view of safety, the security of these operations in space, rather than from the point of view of demilitarization or de-weaponization.
Your question about the Seabed Authority. You want to add up on that?
Yeah. Ma question c'était
My question was the system for seabeds, for the exploitation of seabeds, and the International Authority for Seabeds. I was wondering, is that a system that could actually inspire our system applicable to celestial bodies? Bearing in mind that when it comes to seabeds, it's not possible to declare sovereignty, for instance, on any part of the seabed. That's one example. And also, there is the possibility of appropriating resources. In fact, these are the two parts that were addressed, also in the context of celestial bodies. So, again, could it serve as a model? That's my question. Thank you very much for clarifying your question, madam.
In English, I think I've taken this as a model because, of course, we do not have yet a similar authority like is already in the International Law of the Sea Convention that foresees this authority. But this would be for parties to actually create if they think the idea, and I'm not necessarily favoring this approach, the idea is that you kind of, have a semi-market approach because it's not given for granted to the strongest country. I think that's the interesting new thing. However, you must invest. And you must first give for the exploration a lot, this two fields policy that you have, and then you can maybe exploit at the end. In principle, I want to make it clear that, at least to my opinion, the exploitation of lunar resources and resources of the other celestial bodies is not free. There is a strict prohibition, and it must be freed to a specific international legal regime, which we do not have yet. And my great skepticism is that we will not have it yet because it's in the interest of some countries to have no regime. That's the same as with regard to environmental protection. It's in the interest of some countries to have nothing. And if one last word, sorry, the mechanism of making space law is somewhat difficult, to say the least. It is a system which total blocking, where we have the famous consensus principle. And consensus means no progress, never progress, because if one country opposes, there is nothing anymore. And as far as we do not away with this, I think I don't see any possibility, because there will always be countries, particularly those who profit most from these solutions, that will block everything. So this is another thing where you see that the procedural things intermingle with the substantive things. So it's no surprise that we don't have any particular concrete treaty since 1979. No more treaty. Merci beaucoup.
Juste terminer, il y a un point aussi qui est très particulier avec
Just one final comment regarding space law. There's one interesting issue. You just have one hyperpower, the United States of America. The USA are so far ahead of the game and of the rest. The budgets are so much larger that they do actually control space. That's what they wanted, but they do control it. And private corporations are subject to that control. So what we're facing here is a giant, and a giant who is absolutely unwilling to relinquish its dominance in space, and therefore it will impose its position on other states. Thank you very much for your kind questions, says Professor Hobe. I think that concludes the debate. Thank you.